watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
You shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. We will call the first case today of the Florida Bar versus Russo and Ron.
May it please the Court, Chief Justice Polston, Associate Justices of the Supreme Court. My name is Daniela Roseti, and I represent the Florida Bar in these proceedings. In this case, the Florida Bar is appealing the referee's findings of fact and not guilty findings as to Rule 5-1.1 of the rules regulating the Florida Bar, as well as the referee's reduction of the bar's staff auditor costs and the recommended terms of discipline. The Florida Bar submits that permanent disbarment is the appropriate sanction in this case.
Can I ask you a question right off the bat? The bookkeeper who is alleged to have stolen the money, was he ever charged in criminal court? Was he ever charged?
As far as we know, a police report was filed by Mr. Roth and Mr. Russo back in February of 2009 with the Aventura police. After that, as far as we know, no further action was taken by the criminal.
There was no effort to extradite him. I don't even know if we have an extradition treaty with Argentina, but was there any effort to bring him back to the United States to face charges? As far as we know, no. And in fact, since he left, he was last heard of sometime in September of 2008. And since that time, as far as we know, he fled to Argentina, and there has been no further communication with him. No contact has been made with him by either Mr. Roth or Mr. Russo or again any authorities. Did the bar make any findings, or was there any evidence that he was not the culprit as far as stealing the money?
Well, in fact, the bar's position in this case is that it was Mr. Roth and Mr. Russo. The bar's audit in this case did not per se reveal that Mr. Horigian had not been involved in some of the taking of the money, but our position is that Mr. Roth and Mr. Russo were just as involved. In fact, the auditor revealed that the disbursements that were made, for example, to their operating account, were made to interest in which business ventures in which Mr. Roth, Mr. Russo, along with Mr. Horigian were involved. Apparently, the referee was persuaded by the fact, their position, that it was Mr. Horigian who had taken the funds, but in fact, our audit revealed that the funds were transferred to entities in which they held an interest.
And did the two respondents actually sign all of the checks that were the transfer of the monies, or did this bookkeeper have the authority to actually sign the checks and transfer money?
He was not a signatory in the account. Mr. Roth and Mr. Russo have argued that he forged trust account checks, which is what enabled him to make these transfers. However, Mr. Ruga, the auditor for the Florida Bar, in reviewing these checks which were allegedly forged, he saw that, again, first of all, they were disbursed to entities, they were made payable to entities in which Mr. Roth and Mr. Russo, for example, R&R Consulting held an interest. In addition to that, we saw checks in the amount of, for example, $1.80, which kind of belies any claim that Mr. Horigian had been, making these checks, issuing them to himself. In addition, a lot of these transfers to their operating account were wire transfers. They were not checks. So again, that belies the claim that it was Mr. Horigian. And for that matter, these checks many of them were for a time period after Mr. Horigian had left. Again, based on their testimony, the last they heard of him was in September of 2008, and yet we see between September of 2008 and December of 2008 that over $1 million, $1.4 million, were still being transferred again into their operating account.
So, the bookkeeper was already out of the country at that point?
Yes. Which, and again, they took the position that perhaps he had maybe made some of these checks, there was a delay, I guess, in these checks being cashed, and maybe he had issued them before, but the fact is that a lot of these were wire transfers, so again, that belies the claim. These were wire transfers that were made after Mr. Horigian had fled the country, after, by their own admission, the last contact they had with him.
The bar's position, if I understand you correctly, is that it was not as painted by the referee, where they came into the office one day and suddenly learned that the bookkeeper had been stealing money throughout the years to the tune of how many $1 million. Your position is that they knew about it and benefited from it.
That's exactly correct. In fact, by their own admission, as early as the spring of 2008, they were aware of that there were problems. Mr. Roth testified that Mr. Horigian came to him and told him at that point that there were problems with the trust account.
But there's a difference, and again, I know that the sanction you're seeking is permanent disbarment. There are tremendous, in my view, violations of multiple Florida Bar regulations regarding trust accounts. The question as to whether before they, quote, discovered it, they actually benefited financially. The referee did not find that. He found the respondents to be credible on that issue. Over and over, the bar always says you have to defer to the referee's findings of fact. Are you asking us to reweigh and find that there was direct financial benefit, in other words, that they were in fact stealing from the trust account in order to find disbarment, or is the bar's view that regardless of whether they directly benefited, the sheer amount, $4.8 million, over the sheer number of months or years, makes them responsible as the attorneys? And because to me, I think this is a major issue, whether they benefit. If they benefited, then there's no question. Now we have it at the same level or more than other cases where we have either imposed disbarment or permanent disbarment. So how do we do that, and how do we reweigh that the referee found that there was no financial direct financial benefit?
Yes, Your Honor. And yes, the bar is in fact appealing the referee's findings of fact and the not guilty finding as to Rule 5-1.1. And, our position is that, yes, in fact, they did benefit because, again, at a time when they were aware of the shortages, of massive shortages in their trust accounts, they were transferring funds into their operating account, and as a referee properly recognized, ahead of clients, placing themselves in first priority position ahead of their own clients.
Well, that's that we can find because that happened. In other words, we know that happened, that they transferred money and then they made decisions to who to pay. But there's still one more level, that is that money was taken out to do something in their business. Are you challenging that? In other words, that the $4.5 million that was stolen, that they benefited from a huge amount of that $4.5 million personally by using it in their businesses, using it to fund college or vacations or things like that?
Yes, Your Honor. I believe, again, the referee was apparently persuaded by perhaps the fact that they didn't go out and pay their mortgage or pay their Lexus bill. But yes, they did transfer funds into their own business ventures. And in fact, it was the fact that they were running their business ventures through their operating account, which this court has previously held, that running one's business ventures through the trust account is sufficient to find a violation of Rule 5-1.
Well, I agree with that, and we may disagree. Just that alone may cause there to be a violation of the trust account. I guess I feel like we're still passing. So I understand that they committed trust account violations. The issue is overall the $4.5 million. The referee found that it was the bookkeeper that took the money and used it for his benefit. You are directly challenging that factual finding and asking us to find no, they benefited. Is that correct?
That is what we're saying, and I would say that is also consistent with findings. The referee himself recognized that their argument that the bookkeeper had stolen the money might hold for an isolated instance of conversion, but the sheer size of that shortage, $4.38 million, proves that this bookkeeper had been embezzling for many months, if not years, for this to have been missed, for them to have not known about this and been a part of it. And again, their transfers to their own business ventures, that in itself shows the benefit to them. Again, the forged checks themselves that they keep referring to, those checks, they were made payable to entities in which they themselves held an interest, such as R&R Consulting.
Now, the bar asserts for the disbarment factor aggravating factors with regard to the manner in which the two lawyers attempted to replenish the trust account. I'm not sure we've seen a case really similar to this or like this, but I'm trying to make sure that I understand this aggravating factor. If a lawyer, it's a position of the bar, that if a lawyer all of a sudden encounters and finds that there's a problem with the trust account, and let's assume all other, that there's no self-dealing and all that, that it's a violation and an aggravator if the lawyer tries to place his own money in there to protect his clients, that automatically is a violation and an aggravator, and that's the position of the bar?
I think there is a distinction, Your Honor, between, for example, there's those cases like the cases cited by the respondents, Stanton and Moore, where the attorney, yes, was putting funds back into to try to make whole innocent clients or victims. But in this case, it was completely different. What they were doing was really covering up.
Let's break this down. And so it is a position of the bar that if one encounters shortages, that it is not a separate violation for the lawyer to try to make good on those with his own money.
No,
his or her own money?
No, it's not. Obviously that is something that we would encourage to try to make whole.
Well, that's what I'm trying to do, because we have some precedent that's being created here. What should lawyers do when they encounter situations like this? And if this court is to write an opinion providing referees and members of the bar information as to what do you do to face this, I'm not sure that the code itself delineates precisely what to do. So that's what I'm trying to reach for in looking at this. So there's no per se rule, but if there is self-dealing and then continued self-dealing is what you're saying, that's a different category than just replenishment.
Yes, Your Honor, and I think that this is a perfect case to make precedent on that point. I think that this was, again, a cover-up by them. It was not trying to make whole innocent clients or third victims. They were just trying to protect their own interest, the interest in which they themselves held an interest, as reflected by the fact, again, that they were transferring funds, millions of dollars, into their operating account when they had pending claims from their own clients, soliciting loans from their own clients, as the referee found, without even disclosing to them what the intended use of those funds were to cover the trust account shortages. And there's also a distinction in those cases, I think, that where the attorneys come to the bar, they fully cooperate with us, they're forthcoming, they disclose that there's a problem, and in this case, it wasn't until a grievance was filed against them a year later, a year after they first, by their own admission, learned that there were problems with the trust accounts, that, they said, oh yes, we've been the victims of theft. There was never any, and even after the fact, there was never fully any cooperation with the bar, in the sense of the records that were produced were doctored, fabricated records that our auditor could not properly rely on in conducting his investigation. He had to do so based on the records received directly from the bank. Any mitigating evidence, for example, after the final hearing, we had evidence that was submitted about monies that were actually held in escrow accounts separate from their trust account, which ultimately reduced the size of the deficit. All of this information wasn't brought to our attention until at the 11th hour, after the emergency suspension hearing. And again, this complete lack of cooperation, and again, their attempts to really just cover up the problems, the massive shortages, makes this case different from cases where the attorney is simply really trying to make clients whole, is in no way involved or complicit in these misappropriation of client funds.
Counsel, you're in your rebuttal.
Thank you, and with that, I will save the rest of my time. Thank you.
May it please the Court, Chief Justice Polston, Associate Justices, my name is Brian Tannenbaum, and I represent Mark Russo. The referee's findings are supported by the evidence, particularly that the bar's own auditor said he had no proof that the respondents took the missing money, and their employee probably did.
What about this argument that the money was, some of the checks went directly to business ventures in which they had an interest?
Well, there were forged checks, and the referee found that. He never found that the respondents were responsible for what happened. In fact, the bar's own auditor said that they didn't steal the money and that checks were probably forged. So there's no allegation that the respondents were complicit in the theft of this money.
That seems a little odd that you would steal money and put it into the respondents' business ventures. So this you're saying the bookkeeper stole money and put it in a venture for the benefit of the respondents.
Well, it was also for the benefit of the bookkeeper. Those allegations were made that the bookkeeper had some involvement in some of those real estate and business projects.
What are the dates of these alleged forgeries? How long before everything is disclosed did those occur?
They occurred within the year after, I think it was...
So we're talking about a year, and lawyers don't get it that someone's forging their signatures for millions of dollars on their trust account. That's what this case is about.
Justice Lewis, the checks were not forged in those amounts, and this was a trust account that had over $300 million going through it in a very short period of time.
You know, the more you have, the more you need to be looking at it. So my question is that it's over a year's period of time, and lawyers looking at their trust account don't know that that's not their signature on the checks.
They weren't. And that's part of the problem. And there was negligence in the way that they were not reviewing certain documents in the trust account. One of the things that happened when the bar mentions fraudulent and forged documents, those were not forged by the respondent. This is a bookkeeper who fled to Argentina and a police report was filed, and he has not been charged. It wasn't until...
But you see, the troublesome part, it's like see no evil. I just can hide my eyes as a lawyer and let the money just disappear. Isn't that part of the analysis here, the responsibility of lawyers? And doesn't it at some point build up to the point of, you got to be kidding me? We're not talking one check being forged or a small check being forged. You're talking about a $300 million trust account, and lawyers are not looking after it?
And this was 1%.
What do you think it means to be a lawyer, sir?
Well, I think there's a difference between negligence, gross negligence, and theft.
Or just totally hiding your eyes.
Well, when you look at the cases of theft where the court has disbarred or permanently disbarred lawyers, those are cases where the lawyers were complicit in conspiracies to steal money. All of the cases in which this court has issued suspensions or even public reprimands or admonishments have been cases of negligence or gross negligence. So I think the question you're asking is, what do we do when a lawyer is grossly negligent in operating a trust account? And I believe this court has answered in saying we suspend them, and we suspend them up to 3 years. When they are complicit in the theft of money, which the referee did not find. In fact, the bar's auditor said, I have no proof that these respondents took the money. Then we issue anything from an admonishment like we did in Stanton, or a public reprimand like in Moore, or suspensions in various cases where lawyers committed many trust account violations, including using their trust account for business ventures. So disbarment is not an appropriate sanction in this case because the referee did not find intentional misappropriation.
When did the checks, what's the amount that was stolen?
$4.3 million.
All right. What's the largest check that was written?
I don't know, Your Honor. But they were not checks.
It wasn't like $2. Was it $100,000? Was it?
I don't know the amounts, but they weren't in millions of dollars.
So there was tons of checks then. Were there tons of checks?
I don't know that there were tons, but there wasn't enough where they bounced.
See, for us up here, $4.5 million sounds like a lot of money. So the question I have, and all of us have private practice, have had to deal with trust accounts, is that I can understand an argument where somebody in 1 month steals a large amount of money, and then you say, oh my God, this happened, and then now we go to the next step. But how many months did this span, this theft from the trust account that belongs to not the lawyers, but to their clients?
It was over at least a year. And to answer your question, when you have $340 million running through a trust account, candidly, $4.3 million missing out of that trust account may not be noticed, especially by lawyers who aren't paying attention to what's going on in their trust account and being presented with fraudulent documents saying everything's okay.
Well, where were those checks? Who were they written to?
They were written to various entities. They were written to projects. They were written to just various. Projects. None of them were written to the respondents. None, not one.
Were they written to projects that the respondents had a direct financial interest in?
Yes, but
right,
again,
and that doesn't. What would those projects have had to do? Were there some monies being held in trust because of those projects?
Yes, people had put down deposits on projects, and those monies were being held, and the lawyers.
What kind of business were they in that there was $300 million in their?
They were real estate lawyers, and they were involved in the development of certain projects in which they had clients and other investors.
So is the message that the larger the amount you hold in the trust account, the more you can be free to ignore the quote the small transgressions? Is that what we want to tell lawyers?
It would be clear that they wouldn't be noticed, and when someone's trying to commit a crime by stealing money, that's how they do it.
I think this whole idea that the bookkeeper is operating this trust account and the lawyers are not directly involved is something that if you're saying, do our rules allow it, but don't they require the lawyer to have direct supervisory authority over the bookkeeper?
Yes, but what's interesting is in Stanton, before he had a problem, Lomas came in from the Florida bar and said, this is how you operate a trust account. He ignored that advice, and when that case came to the court and the bar wanted a public reprimand, this court reduced that sanction to an admonishment, and that was a case where there was employee theft by a bookkeeper where Stanton was not paying attention to what was going on in the trust account. And I see I'm out of time.
Thank you.
Thank you.
Good morning. Andrew Berman from Young Berman Carf Gonzalez for Mr. Roth. Just to pick up on the point that counsel was making, in Stanton, you had a situation where Lomas came in and said, one of the most important things you can do is make sure that a lawyer, you yourself, Mr. Stanton, or another lawyer in the firm on a monthly basis reconcile the trust account balance, the trust account ledger cards with the bank account balances. He didn't do that. He didn't follow Lomas's advice. And that's what caused the problem. Had the lawyer done it, it could, you know, the problem would have been caught in a month or two.
Well, how did this occur? What should your lawyer have done to catch this in a month?
What they should have done is, in answering that question, I want to ease into Moore. What happened in Moore is what happened in this case. In Moore, the bookkeeper was giving each lawyer a reconciliation on a monthly basis of their own clients' trust funds. So it was sort of like divide and conquer. So if there are 6 lawyers in the firm, the lawyer over here, the accounts always reconciled, and the lawyer over here, they reconciled, and no one looked at it from 30,000 feet to see the huge deficit. That's exactly what happened here. Mr. Roth testified that on a monthly basis, he was an immigration lawyer, so he had very little trust funds in the account. He said on a monthly basis, Mr. Harigian would give him a reconciliation of the monies that he had in trust, and it always reconciled. And he did that.
So there was at no point during all of this, there was no outside auditor who came in and made sure that all of these trust accounts, I mean, with $300 million, wouldn't you think that would be what a reasonable person would do with that kind of money?
Mr. Harigian was trained as an accountant. He'd come down here from New York to work for the firm, and he had an accounting background.
But he was on the inside. He was the person who was actually writing checks, correct?
Yes.
And doing their whatever internal reconciliation they were doing.
Justice Chris, I agree with you, and I think that rather than having lawyers on an annual basis electronically file and say that the trust account's in order, maybe the time has come to have a CPA audit these things. I know my firm, we have very few transactions in trust, and I have our CPA come in quarterly in order just to make sure. And maybe that's the direction we should be going.
Well, let me ask you this. When the respondents first became aware of a shortage in the trust account, what did they do?
The first time that they became aware was in June of 2008, and Mr. Roth was approached by Mr. Harigian and say that there's a problem with the trust account, I'm trying to fix it, I need $100,000.
Did they notify the bar?
They did not notify the bar.
Why did they not do that?
Didn't cross their mind. Mr. Roth testified that his first and foremost, he wanted to protect the clients. And
how long after that point was it before they notified the bar?
They called, there's evidence in the record, Mr. Russo testified that he, Mr. Kassman, who was a partner at the time, and a third lawyer called the ethics hotline and said, we have this problem of a employee stealing money, what should we do? And he testified that all 3 were told, was this person a lawyer? And they said no, and they said there's nothing the bar can do. It was bad advice, but they relied upon that. And they did that in the same time frame that they called the police. They notified the insurance company. And Mr. Russo hired Mr. Tannenbaum to get involved and guide him along. And in fact, what they did is they shut down that trust account and they opened up a new trust account.
But now, counsel is suggesting, Mr. Berman, that there were transactions and transfers after knowledge of the problem coming from the same account. I mean, that's what I understood her to say this morning.
Here's the sequence of events. Money was put into the trust account in June and July of 2008 to offset the shortages. Now, you all know because Rule 4-5.1 has 6 provisions where money, you get a problem with a trust account where money is not collected for reasons that are legitimate. A cashier's check there's a problem with, other bank checks. So Mr. Roth told Mr. Regine, find out what the problem is. At that point, he didn't know he was the thief. He thought he was the seasoned accountant. He's going to find out what the problem is. Several months, no checks bounced. The first check bounced, I think, in December of 2008. It was at that point in time, and that check was a result of a closing that occurred in August, and a $600,000 mortgage should have been paid off, and it wasn't, and then in December is when a check bounced. And so at that point in time, when counsel talks about money coming in and out, they did not know at that point there was still a deficit. It was once the first check bounced, it was a new ballgame. And in fact, the bar's auditor testified in terms of knowledge and sequence of what they knew and when, that it was all fuzzy. And it's our position that the bar was unable to meet its burden of proof by clear and convincing evidence that they knew at the time that they moved check money out of trust.
So when did the first check bounce?
December of 2008.
And so even though you say there was $300 million flowing in and out of this, what kind of check bounced? I mean, how much was the amount of this?
I don't remember the exact number of the check, but it was a significant amount. It was like 30, 40, 50,000. But the bar's auditor testified that the first deficit that he saw in the account was in April of 2008, but it didn't result in any trust account and any checks bouncing. It took another 6 or 7 months for the first check to bounce. And when Mr. Roth put the money in the summer, he felt there was a stopgap measure. He didn't hear of any more problems. No checks bounced.
So when did they ever, or did they ever? I mean, it seems to me that once you got some notification that there was a problem, which you say was in June of 2008, did they at that point bring in any kind of financial person to look at their books and see exactly what was going on?
No, Mr. Roth still believed at that point in time that Mr. Harigian was honest and he was a seasoned accountant and that he would figure it out.
Before we run out of time, we haven't talked about this yet, but I want to talk a little bit about the promissory note to client Yordi, or
Yes.
Yordi.
Yes.
When, in the scheme of things, did that occur?
That was in July of 2008.
So that was after they discovered the shortages.
The first request for funds was in June, and my client wrote a check for $100,000. Then in July was the $231,000 loan for Mr. Yordi.
So how did the promissory note transaction, how was that supposed to work?
The evidence was that Mr. Roth, the firm had been successful in recovering a deposit for Mr. Yordi of about $300,000 on a condominium that he had purchased or was going to purchase. He said, went to Mr. Yordi. He had known him for a while. He's a businessman in Venezuela. He said, I need a loan, a personal loan, and Mr. Yordi agreed to give it to him at 12% interest at a time when interest rates are roughly half of that. Mr. Roth indicated he offered Mr. Yordi security, but since he couldn't give him a first mortgage on the asset that he offered him, Mr. Yordi instead took a note from La Stancia, which is a company that Mr. Roth had an interest in. And it was satisfactory to Mr. Yordi. Unfortunately, the problems were far worse than Mr. Roth knew at the time, and he couldn't pay the money back in accordance with the terms of the note, but has subsequently entered into a settlement agreement, which we filed with the court a couple weeks ago.
One of the things that you're objecting to is the referee's conclusion or recommendation that as part of any reinstatement into the bar that Mr. Yordi be made whole. Why do you object to that?
Well, there's no authority for that in the rules, and it's our position is so long as they're continuing to make the payments, that shouldn't be an impediment. And the reason why we object is because if you look at the sequence, he was suspended for 15 months, and the payout terms of the note extend beyond that time. So he's basically, if you affirm the referee and his recommendation of the discipline, then he would be suspended longer than the recommendation. And so it could be a conditional reinstatement, and we have no objection that so long as the money is paid in accordance with the settlement agreement, things should be fine. And I think it's important just to state that every known creditor of this theft has been repaid.
Is it your position that there really is a vast distinction between the two partners in this case? Because you said one gentleman is involved in immigration, and all of his cases and files and everything that he had to do with the office comes to him for review, and everything's fine. And it is one individual that has caused this loss, or that's not looked over this?
The partners recognize they have joint responsibility for the trust account. They're not pointing fingers at each other or anything of the sort. I mean, they recognize that they both had obligations. Well,
you made that statement that it was one of them, not both of them, going over the trust account.
No. If you got that impression,
I got that impression.
Each of the lawyers in the firm was given on a monthly basis reconciliation of their own client's trust fund. No one oversaw that completely. No lawyer oversaw that completely and made sure that the gross amounts in the bank account matched up with the gross amounts on the trust ledgers.
Okay.
Thank you.
If I may, very briefly, touching on a point that was brought up by Justice Lewis with respect to, I guess, the timeline from when they first discovered this, that there were problems with the trust account and they're coming to the bar. Again, it was a year later. They learned of these shortages in the spring of 2008, and it wasn't until a year later in 2009 February when a grievance was filed by a former client who claimed that a mortgage had not been satisfied that they first responded to the bar. They claimed they called the ethics hotline, but candidly it's very difficult to believe that anyone from the ethics hotline would have really told them if they had in fact truthfully conveyed the facts.
Well, now you see, but I think that the issue of what they did after the trust account violations were discovered puts this in a different case because of the fact of the loan that they took from the client, Yorty. But you made some very serious allegations that haven't been found by the referee, including that they're saying that the auditor said many of these checks or most of the checks were forgeries, and you're saying, well, there's no evidence that there was a forgery. But how do we reconcile that if the referee doesn't find that they stole the money? How do we and if that's what the bar's case rests on for disbarment, how do we overrule or disagree with what the referee says from findings of fact?
I think the referee's findings on that point were based on the fact that he didn't see any money going, perhaps again, to them paying their own mortgage or their car, but his findings were not inconsistent with the bar's position that monies were transferred to business entities in which they themselves, by their own admission, held an interest.
But did the bookkeeper also have an interest in those businesses?
Yes, and in fact, the bar introduced a listing which showed, and that was the problem, that there were all of these business ventures that they were involved in, that they were running through their trust account. It was due to their running these business ventures through their trust account that ultimately led to the massive shortages in their trust account and the misuse of client funds. So that combined, coupled with their, again, upon learning of the shortages, and here they by their own admission, they learn of the shortages. They're told by Mr. Horigian as early as the spring of 2008 that there's problems, and rather than coming to the bar or getting a CPA to conduct a full audit, they continue in the same pattern of behavior by trying to cover up their misconduct.
But by then the money had been, $4.5 million had been stolen.
By that, yes.
I understand what you're saying about what they should have done after, but just to make sure, there was no more theft.
As far as we know, there was no more theft after that time.
Does that comport with what you said earlier about wire transfers after that point? After the point that the bookkeeper left the country, you said there were wire transfers.
This is money that was owed to clients, which they were, in essence, their position is that they were earned fees, but as a referee himself recognized, this was at a time, these transfers were made at a time when they knew already of the shortages that existed already in the account. So therefore, they placed themselves in first priority position ahead of their own clients. And in their own brief, they recognize that everyone will recognize that technically once an account is out of balance, funds that are being transferred, they're placing themselves in first priority position. It's someone else's money that they're taking for themselves.
Thank you for your
With that, I ask the court to rely on the rest of the arguments made in my brief, and I thank you.
Thank you for your arguments. We will now call the next case, amendments to the Florida Rules of Judicial Administration.
I read this one on my iPad, and I left my iPad back there.
You may proceed.
Thank you, Your Honor. May it please the court. I'm Talbot Dallenberg with Patsy Palmer, representing the Chief Circuit Judges in Florida in this rulemaking proceeding. 4 judicial organizations will address the court today. All 4 are opposed to the term limits on chief judges, and all 4 oppose the rule relating to advocacy before legislative bodies. The idea of a chief judge of a circuit actually originated in the statutes. In 1971, the Florida legislature looked at the disorganization of our trial courts and saw multiple trial courts, each of the trial courts having its own clerk, its own marshal, no unified management for the whole court system, and the legislature proposed a statute which created a presiding judge. And then that statute, the 1971 statute, was reviewed by this court, and this court incorporated the terms of that statute into a rule. In this court's opinion, you looked at the issue of term limits, You determined in that 1971 decision that there would be no term limits for Chief Circuit judges. Following the statute, the legislature proposed to the people a constitutional amendment to Article 5, and that was adopted in March of 1972, the following year. And at that point, the office of Chief Circuit Judge became a constitutional officer. And that is really significant for our discussion today because the Constitution provides, as to the Chief Judge, that there shall be a Chief Judge in each circuit who shall be chosen from among the circuit judges as provided by Supreme Court rule. Now, if this rule, announced in February of 2012, is adopted, this constitutional language will suddenly read, a Chief Judge in each circuit shall be chosen from among the circuit judges who have not previously served 8 years as Chief Judge. It is a modification of the Constitution. And if we think back to...
Well, Mr. Dallenberg, don't you have to read that in conjunction with the modification of the provision with regard to the Chief Justice position of this court, which makes that individual the Chief Administrative Officer for the entire court system?
Your Honor, I think you have to read that whole section and to say that this court's got the authority.
Well, I mean, isn't that what the Constitution says as well?
What the Constitution says...
That the Chief Justice's position is the Chief Administrative Officer for the entire court system.
It is.
Okay. So, I mean, that must mean something as well, that Justice Polston, as Chief Justice, must have certain parameters on the administration. Constitutionally, he has that authority.
We quite agree, Your Honor, but we do not.
But you're saying that he does not have it. I mean, I question, and maybe that as the Chief Administrator, although the court's gone through some modifications internally, but as that Constitution reads, you read out all of that provision for whoever is sitting in the chair. If you say that he is not or she is not the Chief Administrative Officer. Administrative, it seems to me, has a pretty wide berth.
But, Your Honor, we want to concede that the Chief Justice is a chief spokesman for the judicial system. We concede the authority of the Chief Justice, the authority of this court. We do not concede that the provisions in the Constitution allow term limits to be imposed on circuit chief judges. And my only point is that the constitutional language establishing this constitutional officer, a circuit chief judge, provides for the pool from which the chief judge will be selected. And that pool is all the circuit judges. Now,
what does the language then mean that basically says, don't have it right before me, but it basically says that when it comes to the chief judges, yes, they are selected by their peers under the rules of the Supreme Court. And so why wouldn't this be a rule of the Supreme Court concerning the election of chief judges?
Your Honor, it's a rule relating to who can be a chief judge. We concede the authority of this court to determine the method of selection of a chief judge. This court itself could make the appointment of the selection.
I thought it said, didn't you say the Constitution said it has to be by vote of the judges in the circuit?
Your Honor, the Constitution...
Are you saying that we have the authority to select chief judges? Like in New Jersey, that's the Chief Justice does in fact pick and select the chief judges of every circuit.
We submit that
I can just see Judge Perry back there saying, uh-oh, that would be worse than term limits.
Your Honor, you clearly could do that. The question is, do you want to do that?
Well, let me ask you to move beyond the issue of whether we have the constitutional authority to do what we've done, to address the issue of whether it's a good idea to do what we've done, assuming that we've got the constitutional authority. I mean, you can argue that, and you've got some points, but if you move beyond that to focus on the policy aspect of this?
Justice Kennedy, thank you very much, because I think that's probably where we belong. This ought not to go off on constitutional issues. It really ought to go off on policy issues. And on those policy issues, I made one of the points I already wanted to make, and that is to have local judges, county and circuit judges, making the decision means that we are giving respect to the people who know the community the best. We're helping, I believe, develop a collegiality at the trial court level. By not having term limits, we're now putting the chief judge, who's one of the players in our judicial system, on equal footing with the other players in the judicial system. Think about long-serving state attorneys or public defenders, clerks, in places where clerks are not themselves term limited. But a chief judge deals with a very complex system. I respectfully submit that the job of the chief circuit judge is probably the most complex administrative job in the state. Chief justice job is an immense job, but the number of people that a chief judge has to deal with, county commissioners, trying to get court facilities, dealing with the sheriff's office in various ways. It is a really complex job. And
Can I ask a question about that? Because over the 14, first of all, I see certain chief judges in the audience, and I've been on the court 14 years. I have total admiration for Judge Menendez, for Judge Perry, for Judge Moran. I come from Palm Beach County, which is not as big as Miami-Dade, but their tradition has been their 4-year terms, and then that they go on. And we have in Palm Beach County, rotation of judges, and there is, over my 14 years, I have heard on many occasions from circuit judges who cannot or have not spoken up that in certain circuits, maybe not the ones represented here, that it becomes sort of incestuous. In other words, the chief judge gets the power in terms of being able to be elected, and really nobody can challenge that chief judge. And I noticed when we looked at it in 1996, the majority of circuit judges under a survey wanted term limits. Now, I agree here we don't have that information, but how do we make sure that what we're doing, and you say good policy, is in fact best not only for the administration of justice in all of the circuits? Because what you've said would mean that we ought to really say the term should be at least 4 years. In other words, a 2-year term would never be a good idea because of all those things. So how do we balance that and make sure, because you're representing the chief judges?
Your Honor, if the question is whether we ought to be frightened of the power of chief judges, I want you to think about this. Is there any other constitutional officer who is accountable in so many different ways than the office of Chief Circuit Judge? And I submit that there is not. Think about all the ways. There are obviously the traditional ways that apply to all judges, JQC proceedings, investigation by the legislature, and possible impeachment. But beyond that, a vote every 2 years by secret ballot, a removal by the trial judges themselves, and removal by action of this court. Now, removal by action of this court has happened in the past. Trial judges are quite competent to vote a chief judge out if there's been any abuse of power. I respectfully submit that there are more checks against abuses of power of a chief circuit judge than any other constitutional officer. And so the mechanisms are in place and they're being used. So I don't understand the argument that somehow chief judges are going to get out of control. If they do, we're not using processes that are available to us. I'd like to move on to the communication rule, if I may, and make this final point. There are a number of submissions to this court, and none of them suggest that there be term limits for a chief judge. There was not a recommendation by the National Center Study, the consultants. There was not a recommendation of the study group itself, and we have now in commentary before the court multiple comments from judicial organizations, all three conferences, and several bar associations, and all of these are opposed to the idea of term limits for chief judges, and we hope that the court will look at those closely. Looking at the communications rule, we have submissions there. First of all, as this court says itself in its February 2012 opinion, you can't adopt this rule on communication without repealing Florida Statutes 26.55. And my question is, why would the legislature want to cut off that form of communication? And maybe another question is, why would this court not want to promote this kind of communication?
Are we talking about the specific issue of the budget and compensation? Have you been, having been Chief Justice, Judge Perry was head of the Trial Court Budget Commission. There is nothing that is, in my view, and I think the view of the Study Commission, more harmful to the ability of the branch to get its budget priorities than if judges go off on their own and lobby for their own issues. And you know there were some recent examples of where that happened, and it hurt the branch tremendously. Now, I understand, the issue of whether judges can testify on questions affecting the administration of justice and changes in the way the family cases go, or death penalty cases, but we're talking about budget and compensation, and a structure that we have in place with the Trial Court Budget Commission and the DCA Budget Commission that allows for everybody to have a voice. So all this says is it's except as long as you make clear that you're expressing your own personal views, this should come through the Chief Justice.
Your Honor, this court obviously needs to worry about the points that you made, and our submission is that the court is really wise to have leadership come from the Chief Justice and from this court, so we don't contest that. On the other hand, we think it is a mistake to adopt a rule restricting speech. There are two major reasons for this. One is you fall immediately in conflict with the Code of Judicial Conduct. Look at Canon 4B and look at the large numbers of decisions by the Judicial Ethics Advisory Commission on that canon. And
now, on the issue of individual judges expressing their viewpoint to the legislature concerning an issue related to the administration of justice, we haven't prohibited that. Now, there might be some people that would think that'd be a good idea if we prohibited it, but that's not what we've done. I think it would be a terrible idea to do that, because I think judges do have the right to express their viewpoint. What we have said, and maybe we haven't done it in the most artful way, but what we have said is that when they do that individually, they must inform the person to whom they're communicating that they're not doing it on behalf of the branch, that they're speaking for themselves. And that seems like a reasonable accommodation for the sake of clarity. Because I think that what happens sometimes is when one judge goes over to the legislature and speaks to a member of the legislature, they think that that's a judge. They're speaking for the judicial branch, when the position they're articulating may be contrary to the position that this court has adopted, or that the conferences have adopted, or that the overwhelming majority of judges support. But there's that prospect of confusion, and so what we've done is to try to eliminate that potential for confusion.
With respect, Your Honor, it seems to me that the rule itself creates enormous confusion. You create a conflict with a command of Canon 4B.
Explain how we do that. How does it do that to require that the judge simply explain that the judge is not speaking for the branch?
Your Honor, I understand what was motivating that, but how in the devil will that ever be enforced? Think about the enforcement problem. If you really intend to adopt this rule to prohibit speech unless you force some other kinds of speech, aren't there some terrible constitutional traps lurking for us? Think about Republican Party of Minnesota versus White. How do we deal with judges' speech in terms of either limitation or actually directing what judges will say?
The problem is this, Mr. Downward. Would you agree that this court is the policy-making entity of the judicial branch?
Absolutely, Your Honor.
Okay, so if the priorities come from this court, the circuit court conference is comprised of all circuit judges in this state, correct?
Yes, sir.
So if the conference goes across the street to the legislature and takes a position, the legislature would look to that conference and say, this is the position of all the circuit judges in this state. Now, if that's a position contrary to what the Florida Supreme Court has, doesn't that totally undermine the position of this court being the policy-making entity of the branch?
Your Honor, I'm over time, but may I respond?
Please.
There may have been instances of that, Your Honor, but as to the Conference of Circuit Judges, I'm not aware of those instances. But our point here is that a rule that limits speech or that compels speech is bound to cause mischief down the line, and this rule does both those things. It requires judges to speak in a certain way, and then inhibits their speech on certain subjects. And we don't think that those are, first of all, permissible, but we also think there's an enormous problem with enforceability. And we respectfully submit for your consideration the kind of complications that will be into if we adopt such a rule.
Okay, thank you.
May it please the Court. Good morning. I'm Ron Ficarota. I'm a 13th Judicial Circuit Judge, and I'm the immediate past chair of the Florida Conference of Circuit Judges. And our conference adopts the arguments and comments made by Mr. D'Alimberti regarding the Chief Judge term limit issue and the communications rule.
On the term limits, did you endeavor to take a survey, confidential survey of your members to see what their views were on the term limits?
No, we have not.
All right, so it was the leadership that just agreed to...
Yes, ma'am, the leadership and the executive committee, Your Honor.
Okay. Was there any reason why you decided that it wasn't a good idea to get a pulse from your members, which now are how many circuit judges do we have? 599
active circuit judges, right. And I think 138 senior judges, I believe. I'm not sure about that number, but 599 active circuit judges in the state.
Was there, and I'm not saying you should, but was there any thought given to that might be a good way to really give us a sense of how the judiciary looks at the issue of whether there should be some limits on the term of a chief judge?
Well, our executive committee is comprised of representatives from each of the districts, and so that was what we did. We went with our leadership on that issue. So we believe it should be left up to each individual circuit.
What's your the conference? I was looking at the statute because it's
26.55.
What year did the conference was put into was enacted as a part of the Florida legislation? Mr. D'Alimberti educated us on the chief judges, but it was, what, 1939?
1939, yes, ma'am.
And since that statute, 26.55, has been put into effect, would you agree we've had a sort of a sea change in the way justice is administered in the state of Florida?
There's been a lot of changes since 1939.
What would you say in this day and age is the primary purpose of the Conference of Circuit Judges?
Represent the interests of the circuit judge of the state of Florida on issues dealing with pensions and benefits, also to educate our conference members.
I thought, especially with the Trial Court Budget Commission having come into being, that the primary purpose was education.
It's right on the top of the list, Your Honor.
And it's interesting, it's not actually in the list of responsibilities under 26.55. It's not there.
I noticed that.
And the only thing that's there is that you're not less than 60 days before the convening of the regular session, you're supposed to report on any defects in the laws of the state and amendments. And I've never seen that. Has that happened?
Yes.
It happens every year?
Happens every year, and I'll make sure to send you a copy, Your Honor.
Thank you. That would be very...
I think it was sent to the Chief Justice. I'm not sure, but we file that every legislative session.
Okay. And the other part, the responsibility of considering and making recommendations concerning the betterment of the judicial system, it then says to report to the Supreme Court findings and recommendations. So do you see it that the conference really is in existence to separately advise the legislative branch on the recommendations for the betterment of the judicial system, or to be there to advise the Supreme Court of recommendations?
Well, I think the legislature recognizes and relies on the voices of the actual frontline trial judges that are dealing with the statutes they've passed. But we worked well with the Supreme Court. Our conferences worked well with the other conferences, with the Trial Court Budget Commission.
And I totally agree that the conferences over the last decade we have all worked harmoniously together, which is why I was sort of surprised to see the conference being concerned about the changes that were being proposed, not the term limits, but all the other parts where we've really said that nobody is going to be going across to lobby the legislature on budget and compensation issues unless it goes through the Unified Committee on Compensation, where all judges have a voice. If it goes through the Trial Court Budget Commission, where it's that's the mechanisms that we now have for budget and for compensation.
And it's worked well, Your Honor, since we've been speaking with one voice. The last few years we've had these legislative or these judicial summit meetings bringing all the leaders together to make sure that we speak with one voice, that when we go over there, because as Justice Candy pointed out, they just know we're a judge. They don't know if I'm a DCA judge, a county judge, a circuit judge. They don't know. Just, Judge Figueroa, he's one of the judges, and he's saying this. That's why we are very careful, and we all speak with that one voice and set our legislative priorities. And again, the Trial Court Budget Commission, the DCA Budget Commission, they're the ones that are responsible on those budgetary issues.
So what is the part then? So I'm confused about what part, other than the term limits, does the conference oppose in the opinion that the court issued?
Well, I was here specifically to address Rule 2.220B, which recreates by rule the conference. As we discussed, the conference currently is under Florida Statute 26.55, and 3.220B does not become effective until that statute is repealed. Our concern is the changing in the structure of our conference. While consistency among the conferences is a great ideal, the fact is that all the conferences are different. There's been a change in our officers, in our governing structure of the conference, which is a concern to the conference. Currently, we have the leader of the conference since 1937 has been a chairman or a chair.
Well, those internal features of the conference could be fixed, but in reality what we had was the circuit court conference set up by statute, the county by rule, and the district court of appeal by its own charter somehow. So wouldn't it make sense to have some type of uniformity among the conferences, and since we are part of the judicial branch, to have it done by rule?
I think, Mr. Chief Justice, that consistency, as I said, would be ideal, but it doesn't need to be a cookie cutter. We would like to have input. The conference would like to have input into how to structure our governance, what has worked well since 1939.
Well, I think the internal mechanisms of the conference is certainly open to amendment and change and suggestions by the conference. I've seen none filed here. The only thing filed here is that you want to have no changes.
We see and agree that there should be consistency. We would like to have input, and we could certainly file a proposed rule which tracks our current governance, like I said, which has worked since 1939. We've been a very big part of the branch. We're ready to continue to be a big part of the branch and to work with the Supreme Court and to work with all of our partners. Thank you.
Good morning. May it please the Court. My name is Kim Carlton Bonner. I'm here on behalf of the Conference of County Court Judges, specifically to address certain parts of the rule that we feel disproportionately have an ill effect, particularly on small county and single county judges. We are also in agreement with the DCA judges, the chief judges, and the Circuit Court Conference with regard to the arguments that they have made to this Court. As this Court is aware, the 67 counties are extremely diverse within the state of Florida. Our conference, all 322 members, has a lot of various interests to accommodate and to make sure that they are given a voice, too.
I just have a question. I didn't realize county judges, and I maybe should know this, do not get to vote on who the chief judge is?
No, we do.
Oh, you do?
We do.
Okay. All right. So I don't know why I thought it said among the circuit judges, but I guess it's a county judge can't be chosen to be the chief judge of the circuit.
I think the only exception to that I'm aware of, I believe when Judge Demers was still a county judge, he may have been the chief judge within the Sixth Circuit.
I guess maybe if it's a single county circuit, maybe it would be different. I guess it would be if you're...
That could be. We've never had one in our area, but I don't think there's anything that prohibits it necessarily, but it's uncommon, I believe. In those, particularly the single judge counties, the rules as they currently stand, we believe, and we would like the opportunity to comment and offer input on how to accomplish what this Court wants to accomplish, which is to, as the study group mentioned, is to have a unified voice, to have the rank and file feel that they have more of a voice and having that input. As it currently stands, and particularly, and I will focus on the smaller judge counties, in those counties, the county judge have very unique, often familial relationships with their local and state elected officials. They have grown up with them, gone to school with them, lived next door to them. Their children go to school together. And those legislators, when something happens or something is before the body, will often talk to those county judges in their areas. Those county judges, to my knowledge, have not in any way advocated or made any statements in particular that would be against either a position this Court has taken or a policy that it would hold. But the institution as it's set up now to obtain certain approvals, we believe, is overly broad and does not practically allow a way for it to be enforced as some...
So let me ask you this. Are you talking specifically about pay and benefits kinds of issues, or what issue exactly? Because as I understand it, the Conference of County Court Judges also has membership on the Unified Compensation Committee, correct?
We do. I will tell you, with regard to the rule itself says, including budget and compensation issues, it's not exclusive to those. And there are other local issues. I mean, in addition to the state budgeting and all the issues with regard to salary and benefits, there are often in these counties issues that have to come before a county commission, for example, for funding of specialty courts or teen courts, with regard to technologies, with regard to courthouse issues, with regard to security. Many of those things happen on the local level. So despite the fact that funding for the most part has shifted to the state, in those counties, those relationships, again, are extremely important.
And I understand that there are still things that that county commissioners pay for in the counties and the circuits. But I guess I'm concerned about what exactly it is. I'm really not, I don't have a handle on what exactly it is that county judges feel that has been taken from them by these rules, because as we've already discussed, the rule says you can go over and talk to whomever you want to talk to, as long as you make it you make it clear that you are talking individually. And so if county judges are on board with the whole notion that we are taking a unified approach to various issues, then I'm still having a problem seeing what the real issue is here.
The real issue is, in these counties, when those conversations are happening, if, for example, there is a question asked that perhaps this court has not been made aware of, or even if it is with regard to what's the status of judicial pay, it puts a burden to almost Mirandize the listener in a county where the county judge and their elected official might live next door to each other. And I understand the policy and the reasons behind doing this, but as a practical matter, how do you enforce it? What is it they're supposed to say? And there is no provision in the rules for obtaining any type of approval by this court.
You know, Mr. Dallenberg also talked about enforcement, and I guess if we're all in this together, why do we concern ourselves with enforcement? If we are all a part of this branch and we all want to do whatever is in the best interest of the branch, then why concern ourselves with enforcement if we are really... we can go over and talk to whomever we want to about the policies of the court, or we can go over and talk to them as long as we tell them, look, this is my individual view. So why are we concerned about enforcement?
Because although it's hard to imagine in the current environment that we have, but what if there were
how we get it is it comes back to us. Well, Judge so-and-so has said, this is what the branch is interested in.
And if there were specific instances, particularly with county judges where that's happened, that have been against the grain or the wishes of this court, then I'm unaware of that of recent...
Well, it's happened because, you see, this is the way it occurs, and I think some of the people on Trial Court Budget Commission could tell you, Judge Susan Schaefer could tell you, that what happens is you go and you lobby, and the legislators are very happy to know when there is a unified voice. And then we're looking to, say, increase the compensation for our employees, our thousands of employees who have gotten not a raise in years. And or we're trying to get more judges, whatever it is. And a legislator says, well, you know, so-and-so, or I've talked to people, and they say that really just give us more pay, we'll work harder. I'm not saying specifically that's the quote, but and so that everybody in this branch, every judge is an independent constitutional officer, but everybody in this branch is also part of this branch, and all this rule is saying is that if you are going to talk to your local legislator about something that you think is more important, that what the branch has lobbied, that you say, I'm speaking for myself, and that's all I can do. I am still having trouble understanding how it is that is a burden on an individual judge.
And respectfully, Justice, I think as currently worded, the rules suggest more than that. And with regard to the uniform committees, for example, I would note that with the 322 members of the county court, this court selects those bodies that give it advice, and we believe that, if given the opportunity, we would like to present to the court the position or an idea to consider,
do you have any...
which would be that if the court insulates itself in some respects from the funnel of input from the rank and file, then that is counterproductive to what you wish to do, which is to have a uniform voice. Having the various committees as currently codified, again, having one or two people on a committee that will pass something with a majority of 8 or 9 members, and all of the committees have overlapping memberships, may be something that the court would wish to consider. We do support having a uniform voice within the court. But as these rules currently stand, we believe that they have, a disproportionately ill effect, particularly on smaller judges, smaller county judges, and creates an institutional method of getting these things.
Well, let me ask you this about this whole notion of judges and what they say when they go across the street. I don't recall seeing, but did you propose some change to the rule that says that you need to have make it clear that you're speaking individually? Was there any proposed change to that rule?
We did not propose any amended language, but we would like the opportunity to do so if given by the court to accomplish what it is you're hoping to accomplish. But again, the rules as interpreted completely, even any rule that affects speech at some point is going to affect protected speech. I believe my light is blinking, so I'm out of time.
Thank you. That's the one.
May it please the court. I'm Steve Northcutt. I'm president of the Florida Conference of District Court of Appeal Judges. And we filed 4 comments about 4 of the rules. My colleagues have touched on 2 of them, and I don't propose to belabor that points unless you have some questions, maybe not on the last subject, but I do want to endorse and adopt the positions and the arguments that my colleagues have made as to those points. And I also want to point out that the district courts of appeal are in a slightly different situation with regard to 3 aspects of the rule change. And the first difference between the DCAs and the trial courts generally is that for 55 years, Florida law has specified that the selection of a district court chief judge is by the judges of that court. And I think Your Honor pointed out, or it was pointed out today, that the rule doesn't actually say that with regard to circuit courts. So we do have that difference, and that was written into the statutes in 1957 when the DCAs first came into existence, and it's still on the book, section 35.12. Then in 1972, with the revision to Article 5, we have the current provision, which is at Article 5, Section 2, Parent C. And it actually states it a slightly different way. It specifies that a chief judge for each district court of appeal shall be chosen by a majority of the judges. The statute doesn't say that.
You're addressing the removal aspect?
I'm addressing the removal aspect and the term limit aspect, because we contend that both of them impinge on the authority of a majority of the judges of a district court of appeal to choose their chief. This court, earlier this year, in the Telly case that has been submitted in writing, I think, by Mr. Dallenberg, wrote that, well, let me see if I can find it here. Withdrew from the previous Cook case on the issue of whether charter counties can impose term limits on their local officers. And this court wrote that Cook undermined the ability of counties to govern themselves as that broad authority has been granted to them by the Constitution. And now this power granted to district court judges by the Constitution is not so broad.
DCAs have home rule power.
We have home rule power with respect to the selection of our chiefs. That's about it. And so it's the same principle applies. Now, don't get me wrong. We think that the narrowing or the draining of the pool of circuit judges who are available to be chiefs is not a good idea. I mean, we don't think it's good policy to impose term limits across the board for a variety of reasons that we have outlined in our written submission. But we have the additional arrow in our quiver, and that is that we think the Florida Constitution leaves that authority both to select the chief judge and to remove the chief judge to the district court judges. I'll point out another kind of an interesting twist, I think, is that the rule as it pre-existed the change made by this court in February provides that a DCA chief judge can be removed by a vote by a 2/3 vote of the judges. And I actually think that violates the Constitution, because the Constitution says chosen by a majority of the judges. And I will submit that the ability, or if that constitutional language was in the rule, there would be no need for this court to ever have to remove a DCA chief judge. Because a DCA chief judge, if the rule complied with the Constitution about what it took to remove a chief judge, then a DCA judge would have to keep a majority of the judges on his or her court happy and satisfied that the judge is moving the court forward, not bringing the court into disrepute.
Well, but couldn't there be circumstances where a majority of the judges on a particular court thought that?
Yes.
But the chief judge was bringing the whole branch into disrepute?
Yes, sir. And we have, and we all know the example you're talking about. But under
I'm not talking. That's a hypothetical.
Okay. but it's not hypothetical that in that hypothetical instance, it took a 2/3 vote of the judge's court of that judge's court to remove him. And I submit that if the rule reflected what the Constitution says, which is a majority of the judges could remove him, or if there is no majority, the Chief Justice can. That's what the Constitution says. That hypothetical situation would have been resolved far sooner by that court. That's my view. We can't know for sure. All I know is that we've rocked along for 55 years, and the time that it became a problem, I think the real problem there was the 2/3 vote requirement in the rule, not in the Constitution. And I recognize that there was nothing about that in the report of the governance study group or in the consultant's report, but there it is. If the court has no more questions or comments about that, I would like to turn to our last point, which has not been raised by my colleagues, and that has to do with the provision inserted for the first time for the DCAs that the failure of a judge to comply with the directive or order of a chief judge is deemed a neglect of duty, and the chief judge can essentially institute a disciplinary process against that judge. Because one of the differences between the trial courts and the DCAs is that we are a collegial decision-making body. The majority of you have served on a DCA, most recently Justice LaVarga. We passed through anyway.
He was a pastor.
But you know from your experience on those courts, just as you know from your experience on this court, that the collegial decision-making process is carried over into the administrative process.
I'm sorry, so tell me the objection that what specific provision do you object to as it applies to appellate judges?
I'm going to find it right here, Justice Perriente. I hope.
But if you don't, wasn't your point that the chief judges of the district courts don't really issue directives to the judges? It's a different. They don't assign judges in the same way that the judges of these chief judges of the circuit courts do. It's just a different dynamic entirely.
It's a different animal, both in terms of the complexity of the job and in terms of the manner in which the job is done. Appellate courts, almost just because of the nature of their decision-making process, tend to administer their courts collectively. I know, for instance...
But what this would provide, just give me the specific provision.
It's Rule 2.210,
and it would say,
A,
says
2,
now
B,
what?
C, and G, and it says, and this is generally, the failure of any judge to comply with an order or directive of the chief judge shall be considered neglect of duty. And we've not had that in the DCAs before. And we're concerned that that is going to upset this collective administration.
So you don't think the chief judge of the appellate courts needs that authority?
I do not think the judge needs it.
I think because I'm sure that as to the others, this was a recommendation
Absolutely.
of the
and
branch.
If you go back and you look at the consultant's report, it refers to comments by some circuit chief judges. There's no mention of District Court of Appeal, and the reason for that is that there's not a problem. You know, if I'm president of the conference, I have an executive committee consisting of the chiefs, I called them up about this and said, hey, take a look. What do you think? What are your issues? They all polled their own judges. That's because that's how it's done. And so I'm afraid, though, that but that also leaves room for disagreement. The role of a chief judge, and I submit a chief justice within the court, is to, I think, facilitate that consensus-building process and then to carry out the consensus.
I guess it would be a hypothetical because I don't know it's ever happened. I mean, the issue of how cases are assigned, and what if a judge says, well, I'm not going to sit that week?
I'm out of time.
Just what would be does the chief judge have the authority to say, no, you have to sit?
I think perhaps, and I think the group would. All I know is, I've only been around for 15 of the 55 years of DCAs. I've never even heard a story like that. So, I mean, in my court, if we're behind tonight, we have a list of cases that circulates. Justice Kennedy had a lot to do with that when we were working together. A list of cases that circulates about how old the cases are, and it's a shame from the group. I mean, no one is going to buck the group, and I think that it's important that we leave it that way. Thank you very much.
Thank you. Thank you all for your arguments. At this time, the court will take its recess for 10 minutes.
Your Honor, may I ask a question? It was not clear to me whether the court was inviting a submission on the communication rule.
No.
Thank you.
All rise. All rise. Supreme Court of Florida is now in session. Please be seated.
The next case is Taylor versus State of Florida. You may proceed.
May it please the court. My name is Frank Tassoni. I represent Mr. Taylor in this action on appeal. And also I would focus primarily and probably solely on our Claim 1 dealing with effective use of the court or the defendant's psychologist in this case. And in this case, trial counsel indicated that Mr. Chipperfield indicated it was probably the worst set of facts he had ever heard about someone's childhood. He contacted the psychologist who was retained by the defendant.
Could you give a little brief outline of how old was this defendant when he committed this crime?
In his, I think, mid to late 20s, I believe.
Okay. So did they call any witnesses in the penalty phase?
Family members, friends, things like that,
right,
to describe parts of this young man's upbringing.
And then there was a expert that the defendant had hired. That was who?
Well,
that was Dr. Kropp.
Dr. Kropp was hired by the defendant. Also, there was I don't know whether he was hired or not, but there was a consultation with a Mr. Schutz.
Well, what is, at the evidentiary hearing on this, normally or more, prevalent is that there's another mental expert that testifies to some things and you go, oh my goodness, how did you not portray this information? You didn't put on your own.
Did not do that.
So did you put Dr. Kropp on?
Did not put on Dr. Kropp. We relied on Dr. Kropp, on the testimony of trial counsel and on the communications between Dr. Kropp and trial counsel.
And I thought that trial counsel said, and now again, it's not really the magic words of strategic decision, but essentially that they did not see that Dr. Kropp would, on balance, help the case. Is that correct?
He did say that, and I think...
So, again, now we're here. The judge made what? Did the judge find that was credible, that was a reasonable strategic decision?
The trial judge? Yes, he did. Okay,
so how do we... what case tells us that we should, once there is a mental health expert hired, that the defense lawyer looks at what he has to say and makes a decision that on balance it will not help the case, that we would say that's an unreasonable strategic decision?
And I certainly think that is the court's reasoning in a number of cases going back a while. But I guess the question that I present to this court is there any reason, any valid reason for not presenting that at a Spencer hearing?
Justice Perry.
Well, I thought that not only did would Dr. Kropp not help the case, was the testimony that he would hurt the case?
Well, there was testimony at the hearing that Mr. Chipperfield indicated that Dr. Kropp was afraid of the antisocial personality brand that may be delivered, but in fact, Dr. Kropp indicated that while he may have had some antisocial personality aspects or indicators in the past, that was not the case. Now, clearly, what would have been presented to the trial judge at a Spencer hearing would not have been rainbows and butterflies, and there would have been bad things in there. But the man had just been convicted of kidnapping and killing, and I guess my question is...
So what would be... But So there were things that could have not been very pretty for Mr. Taylor. But what is it that Dr. Kropp could have offered that really would have been helpful for Mr. Taylor?
I think that what he could have done and what he should have done, and I regret not putting on another expert at the post-conviction hearing at the trial level. But I think what he could have put on was describe how an individual, and the evidence in this particular area has increased dramatically in the last several years, is how an individual with certain risk and protective factors, what the probability was, not probability, but what percentages of people who commit crimes like this because of many risk factors and lack of protective factors.
I guess what I'm looking at is that we have seen in the past, in cases where we found deficiency, not only isn't a mental health expert hired, but you got lawyers that will sort of bring in a few witnesses at the, almost off the top of their heads. Here at this penalty phase, there was the father, the younger sister, brother, aunts, niece. They had a supervisor who knew at the prison who knew Taylor, a licensed clinical social worker who interviewed the Taylor's family and found 4 non-statutory mitigators. Even if we skip over deficiency, I guess, and this goes to the question of what could Dr. Kropp have added, and as Justice Perry said, it could have detracted. How would it possibly undermine our confidence in the outcome of this penalty phase?
And clearly, with the case law, the prior case law of this court, it wouldn't. But
would what?
It would not undermine the confidence in the outcome of this case. But I suggest to the court, based on its prior case law and its precedent, that what prejudice would occur if the defense counsel had put this on in a Spencer hearing?
All right, so now you're agreeing that the penalty phase, the actual penalty phase, it doesn't undermine confidence. Now you're suggesting that there ought to be an obligation on all counsel to sort of throw in the kitchen sink in front of the trial judge just to see if something will stick, even if it's going to detract from the picture that they've already portrayed to the trial judge?
I rarely use all or never, having reached my age. But I do not understand, and in the cases that I have seen, that I've read about, how presenting something to the trial judge who has already listened to the testimony, heard the recommendation of the jury, could think even worse of a particular defendant.
Well, that doesn't undermine confidence. And Dr. Kropp is one of those experts that we have seen a lot over the years. This is like the worst diagnosis for a defendant that I think I may be misremembering, but he has almost nothing that I'm seeing that was even remotely helpful. Give me what you would think. He said he had antisocial tendencies. He was impulsive and he acted without thinking. Is that the part that you would say should have been presented and would have really given a home run at the Spencer hearing?
I don't know what home run would occur at a Spencer hearing to begin with, but I think what everybody is interested in and what the trial judge should be interested in is that maybe it's just human nature, I should say, rather than a legal issue. Why did this happen?
And so what would Dr. Kropp have said about why did it happen? I mean, this was a robbery and a first-degree murder. A robbery. So it's not like it's a crime of passion or something. It's a calculated robbery and murder. So what is it that Dr. Kropp would have said?
Well, in terms of, and this is not, and I interviewed Dr. Kropp long ago, and I'm not suggesting that what he is or what he would or would not have said at the Spencer hearing. What I do know is that that the Department of Justice, in terms of these risk and protective factors, actually predicts the probability of someone sinking to this low depth, I think that should have been presented.
Have we had that kind of testimony before?
I'm sorry.
The probability testimony. Have we had that kind of testimony before?
To my knowledge, no.
Did you put on evidence at the evidentiary hearing about that, or are you just speculating?
No, I did not. I admitted that up front, that I did not put on evidence, and in retrospect, that was a poor decision on my part.
Well, that's helpful to clarify where we are, but the speculation is just kind of beside the point. It does no good to speculate. We can't make a decision based on that kind of speculation.
Well, and I go back to my original statement, and that is, if Dr. Kropp had spelled out all the bad that he had, and whatever good he had, whatever that is, how would it have hurt Mr. Taylor at the Spencer hearing?
So that's a new standard, you'd agree. I've never heard that. We would be changing. That's a change in the law. The standard would be that he should have, a new penalty, a new Spencer hearing in front of the trial judge under the theory that if you have something that wouldn't hurt, you should put it in? I mean, you're an experienced lawyer. What kind of rule of law would that be?
I think it would be very, very difficult. I think that the mental health science is changing rapidly. And this is just my opinion alone. I think that is coming. But clearly...
But it seems to me that your statement about the probabilities of this based on factors and people... I mean, this took place in 1999?
I forget the original trial date. It was late 90s.
And it just... We certainly have not, over these years, and I've been dealing with death penalty cases since the 80s, and I have never seen that kind of testimony where a doctor gets up and says that based on these factors, there's this probability, and I don't think that that's what Dr. Kropp said. So how in the world would... It just seems to me that your argument it has no basis in anything that's in the record.
I agree that testimony is not in the record.
And Dr. Kropp never said that.
And Dr. Kropp never said that.
So even if Dr. Kropp's have been put on the stand, that kind of information would not be in this record, correct? That there's a probability of this.
I think someone asked the date of the case. I think it's a 1997 event, not 1999.
Okay.
Whatever I said would be simply my conversations with Dr. Kropp, and certainly not a part of the record. But and I said probabilities, and that may have been too strong a word, so I don't want to have the court believe that someone assesses certain percentages of someone committing crimes. But there have been studies, and I should have put that on at the trial court level. I think it should have been put on in front of the Spencer hearing.
You're in your rebuttal.
Thank you.
Good morning. May it please the court. Charmaine Millsaps from the Attorney General's office representing the state. I'd like to get some dates straight. The crime occurred in 1997, but the trial occurred in July of 1999. The defendant's date of birth is 9/19/1960, making him 37 years old on the date of the crime. What counsel, and then
and what kind? Let me ask you that. As a part of, he was 37 at the time of the crime, you said, and so what kind of history did he have? Criminal history?
An extensive criminal history. 22 convictions, most of which were nonviolent, but one of which the trial court relied on heavily in this sentence, was a robbery that was similar, although the victim lived there. It was a aggravated robbery. But in this one, the woman that was making the deposit, he stabbed, and she died. So the crimes were similar. In both cases, he was robbing women at banks. Okay, so...
but he actually stalked her, right? Didn't he? I mean, he targeted her, did he not?
He targeted her, yes. He lived close to the... She was the manager, daughter of the owner of a Buddy Boys in Coley Cove, and this...
Did he ever work there?
She worked there, yes, she did.
Did he ever work there?
No, he lived... He lived at a trailer park very close to it, and in smaller counties, these country stores operate as Publix /banks, and so they are significant deposits. She was depositing over $6,000. That's the cash part of the receipts that she was depositing in the bank on December 29th, 1997. So, does that answer your question, Your Honor?
Yes.
But I'd like to talk a little bit about Dr. Kropp. All right, starting with, there were two counsel here, Alan Chipperfield and Patrick McGinnis. Both of them are experienced capital litigators. Alan Chipperfield had been trying cases with the Public Defender's Office. He had 15 years of capital experience by the date of this trial. In other words, by 1999. So we have not one but two highly experienced capital litigators retaining mental health experts, specifically Dr. Kropp, and jointly making the decision after repeatedly talking to Dr. Kropp not to present him. For example, Dr. Kropp interviewed the defendant on September 23rd, 1998, and defense counsel was present for that interview and took notes. After that interview, Dr. Kropp told counsel that he did not see any neurological problems. Dr. Kropp then produced a report dated September 8th, 1999. Oh, incidentally, this was close to 10 months before the penalty phase. So this is not any last-minute hiring of experts. This conversations between Alan Chipperfield and Dr. Kropp have been going on for months. Dr. Kropp's report says there is no evidence of any major mental illness. And he said the psychological testing that he performed was, and I quote, inconsistent with any organic impairment, no evidence of any major mental illness, and, quote, no significant psychopathology. Now, so they made the decision not to present Dr. Kropp because Dr. Kropp could not help them. But let me tell you what they did present. Not only were there many of the witnesses that Justice Periente referred to, but they presented the defendant's father, younger sister, half-brother, two aunts, a niece, a stepdaughter, a bus driver who drove the defendant to school as a child, two former employees, a stepmother, an ex-wife, the current wife, a former cellmate, a supervisor at Arizona State Prison who knew the defendant, and then a licensed clinical social worker, Dr. Sept. So this was an extensive, well-researched penalty phase. They had obtained school records, employment records, prison records. So
was there any mental health issues when he was a young child or young adult or any of that?
No, Your Honor, not really. Really what all this was going to was this defendant did severe poverty and neglect. Most of these witnesses testified to the defendant's what Chipperfield referred to as the most deprived childhood he had ever heard of. So that,
of course, he's 37 at the time. That's even, I mean, again, that was what was presented, but there's no way to spin that, and I think Mr. Tazones admitted, so for his view is, but you should have put it on the Spencer hearing. So could you respond to?
This court has directly rejected that argument in a case called Bradley. All right, that's exactly the argument made in Bradley, and Bradley was very much like this. It was Dr. Kropp. Oh, and incidentally, Dr. Kropp it comes up in 52 of your opinions over the past 20 years, starting in 1988. So Dr. Kropp is a well-recognized expert, and when he tells you I can't help you with the defense, that pretty much stops mental mitigation. But in Bradley, what they were arguing was very much what they're arguing here, which is once in Bradley they didn't put on the mental health expert, and they argued they then had, and I quote, an obligation to change the strategy at the Spencer hearing, and that what counsel should have done, and he had nothing left to lose. And so counsel should have then put the expert on at the Spencer hearing. That's exactly what this court addressed in Bradley, and that's exactly what you rejected. First of all, Your Honor, nothing left to lose is not the standard under Strickland. The standard under Strickland for prejudice is undermine the confidence in the outcome, meaning the outcome of the Spencer hearing. So what you would have to do, a trial judge is just as unlikely to change his mind when presented with, there's no major mental illness here. If you put Dr. Kropp on in front of the trial judge at the Spencer hearing, and Dr. Kropp testifies that he has no significant psychopathology, that's not going to help you. But what you might do, and it's not clear that judges have a different view, trial judges have a different view. What you might do, though, is open up antisocial tendencies. That's the word he used, Dr. Kropp used. Now, he did end up finding that his antisocial tendencies had decreased over the years. But that would not, a trial judge faced with that, there's not going to be any evidence that a trial judge is going to find that compelling mitigation when Dr. Kropp basically says there's no mental mitigation here. Now, Your Honor, I think you picked up that really there's been sort of a shift to what risk assessment analysis. That's not what Dr. Kropp did here. He did neuropsychological testing, and his report is in. Dr. Kropp, no mental health expert was called at the evidentiary hearing. Dr. Kropp was not called. Dr. Kropp was not asked about risk assessment, and there's no evidence of risk assessment. So I think this court has directly rejected the argument that counsel, the minute he gets a death recommendation out of a jury, has to automatically change his strategy and Spencer hearing and put on something like Dr. Kropp. There's no major mental illness here. There's nothing mitigating to present, and that's as equally true in front of a jury as it would be in front of a trial judge. And there was both no deficient performance from not calling an expert who cannot help you, and there's no prejudice because there's no evidence that the judge would have a different view. Thank you, and ask you to affirm the trial court's denial of the 3851 motion.
Thank you. I will waive rebuttal. Thank you for your arguments. The next case and last for the day is Cortez versus Palace Resorts.
Good morning, Mr. Chief Justice, and may it please the Court. My name is Carlos Gonzalez, and along with Gary Davidson, I represent Shala Rabi. Ms. Rabi lives in California. She was sexually assaulted in Cancun, Mexico, and she filed suit in Florida.
Can I ask you at the outset, could you explain the basis for your assertion of the existence of express and direct conflict?
Yes, Your Honor. In Kinney, this Court began by saying, as it reshaped forum nonconvenience law in the state of Florida, it began by saying that a plaintiff's choice of forum is entitled to substantial deference, and that the plaintiff's selection is only going to be challenged when the defendant can show that there is, or that the private interests that the defendant is interested in protecting outweigh that forum choice. In articulating that...
Now, isn't it the case that the third district here acknowledged all that you've said?
It did acknowledge that statement, correct, Your Honor, but then in its application of that statement, the court simply said that because Ms. Robbie was not a citizen of the state of Florida, that her choice in this particular case would not be entitled to the significant deference that otherwise it would be entitled to. That's in conflict with this court's statement in Kinney for two reasons.
Well, because in Kinney Kinney involved not a citizen of the United States. They were a Delaware corporation.
Correct.
So we made the statement about that, and we adopted a rule, and the rule is, so the facts of Kinney involve an out-of-state plaintiff. Did not?
That's correct, Your Honor. Actually, and in Kinney, I would argue that in Kinney, the contacts, both with respect to plaintiff and defendant, were actually more tenuous because the defendant in Kinney only had the Continental Insurance Company only had a regional office here in Florida, and there was no discussion within the decision itself as to what role that regional office was playing in the state of Florida. Contrast that with the defendants in this case. As Judge Rothenberg pointed out in her dissent, the defendants in this case are the managerial, operational, and public relations arm of this company. Everything that has to do with Ms. Robbie's claim, the negligent packaging claim, the negligent vacation packaging claim, was birthed in the state of Florida.
Well, that makes it that's what I want to make sure you've addressed the conflict issue before we go on to the merits. So.
Absolutely. To conclude my answer, Justice Kennedy, in adopting Kinney, this court also said that it was going to apply federal law to the extent that it harmonized with each of the Kinney standards. Federal law makes perfectly clear that a U.S. citizen, in fact, the 11th Circuit recently in a case called Profit said that the deference that is owed to a plaintiff's choice of forum is at its highest when that plaintiff is either a citizen, resident, or corporation of the United States.
Well, but you're saying there's express and direct conflict because we make a general statement that we're adopting federal law, and then you got to go over to look and see what the federal law is. That creates express and direct conflict?
Not at all, Your Honor. I'm simply citing to that federal precedent to flesh out what this court's statement in Kinney.
But to determine if there's express and direct conflict, we got to look at the decision on review and the decision that you assert that it conflicts with. And I'm having trouble seeing how there's anything here other than a difference about how the various factors in Kinney are applied. And it seems like your argument essentially would mean that there would be express and direct conflict under your understanding of it anytime a case came along where we disagreed with the particular weight given to the various factors under Kinney. Isn't that correct?
No, Your Honor, because what's happened here...
I thought you'd say no.
Well, what's happened here, Judge, is that the third district, the majority, actually cites the standard. And if they were just citing the standard, that doesn't give us express and direct conflict. I concede that point, but that's not what happened here. The majority decision here actually misapplied the standard. They said, sure, Ms. Robbie, or we recognize, I believe is the wording of the court, we recognize that a plaintiff's choice of forum is entitled to deference. And then what they do? They ignored that. They ignored the statement because what they said was that because Ms. Robbie was not a citizen of the state of Florida, she was not going to receive the deference that federal law, which this court incorporated in Kinney, mandates.
Well, we're going to get into, I've read all the federal cases, and the problem when you try to compare the federal cases is that for federal jurisprudence, federal district courts can transfer anywhere in the United States. So when they talk about a foreign plaintiff, they're really talking about a plaintiff that either is from Mexico or Scotland or, some other country. But the reason I think that what I was trying to sort of guess was a friendly question for you is that Kinney involved not a Florida plaintiff. It involved United States plaintiff who we still said, and we adopted the rule that that choice of forum is entitled to great deference. And I don't think that by the statement there that a foreign plaintiff is given less deference. We never said in Kenny that a United States citizen's choice of initial forum is given less deference. And I think that's where the conflict is. But I'm more my interest here is that, is there a place in the United States where you could have, which had more of a connection to this lawsuit, where you could have gotten jurisdiction over the defendants? I mean, these are, as I understand, these three defendants that are left are actually doing their main business in the state of Florida. Is that right?
Yes.
So I am trying to understand how this whole idea of forum nonconvenience, they think that it's going to be more convenient for them to litigate in Mexico when what you're saying is the cause of action against them is for negligent vacationing packaging that arose within this state?
That's absolutely correct.
But you may have, I mean, from my point of view, I'm trying, and maybe this is jumping ahead, where we've had negligent supervision cases, where can you make a connection between a sexual assault that occurs in Mexico, where the supervisor, the employees or whatever are in Mexico, and somebody, what kind of negligent vacationing, where do you get legal causation? Where do you get your cause of action? And maybe, that could be a motion to dismiss on another basis if you survive this, but I'm just not getting the connection between them telling people you can go down to Mexico to do timeshare and the foreseeability of you being sexually assaulted by a masseuse.
Two responses to that question, Judge. First, I agree. I think that challenge that you're articulating now is a proper challenge for a substantive motion to dismiss for failure to state a claim if they get to that point. But with respect to how we establish the connection to this forum in Florida represents the operational hub of Palace Resorts. And in fact, in discovery that we received from a prior defendant, Costco, we learned that all of the complaints regarding Miss Robbie's sexual assault in Mexico were sent to the Florida defendants. We learned that Miss Robbie's vacation monies, funds that she paid for this vacation, also were sent, at least part of them, to this forum, to Florida. We learned that the vacation package itself was created in Florida. The company is run in Florida. Florida is the hub for this company.
But your personal jurisdiction over the defendants, because there's obviously jurisdiction, that's what forum nonconvenience assumes, there's jurisdiction and proper venue.
Yes.
So we don't have, arises out of their doing business. You didn't allege that also that their actions, or maybe you didn't have to because they didn't challenge personal jurisdiction, that the actions in Florida gave rise to the cause of action, which is another separate basis for jurisdiction. So you never had to litigate what basis you were asserting personal jurisdiction under? Do you understand what I'm saying?
Yes, Justice Barrington. With respect to these Florida defendants, that's correct. We did not litigate that specific issue.
But because it strikes me that if you have something, say, that where not only are the defendants present in the state of Florida, and so you have personal jurisdiction based on this is their main headquarters, but also that the actions in which they're sued gave rise to that jurisdiction within the state, there wouldn't ever be, in my view, a basis then for ever invoking forum nonconvenience because the very tort arises out of the actions. And that never, did you ever raise that as the issue?
I see what you're saying, Justice Barrington. In
other words, if the accident occurs in Florida.
Correct.
No one's going to say, well, for the most part, that's going to be the proper site. So here you're saying the cause of action arose in Florida. And I'm not seeing, I just didn't see if it was litigated that way because that's, to me, the easiest answer here.
Well, we certainly alleged in our complaint with respect to the negligence aspect of the counts that remain in terms of the Florida defendants that, yes, in fact, our cause of action does arise in the state of Florida because our negligence claim flows from the actions taken by these defendants in the state of Florida. Yes, Ms. Robbie was assaulted in Mexico, but this is not a claim based on a civil action against an individual who assaulted her in the state of Mexico. That probably would be a more tenuous issue for us. Your question, though, also raises a secondary issue, which is many district courts of appeal have wondered why it is that a defendant in the context of forum non could ever raise a forum non defense when they are being sued in their own backyards. And that's a problem that even Judge Rothenberg noted in her dissent. It strains credulity that these defendants, and at this point we're just talking about the issue of whether or not we can even litigate in the state of Florida. It may be that a judge on remand, if the court does reverse this case, does decide that there is no substantive claim pled at law. But right now, with respect to Ms. Robbie's right to invoke the jurisdiction of the Florida courts, the issue becomes what connection do these defendants have? All that they have said, incredibly, is that they would rather litigate in Mexico, in Cancun.
And what did you learn about, and the other part about this sending something to Mexico is that, for a United States citizen to have to litigate in Mexico, didn't your expert talk about even trying to get a lawyer in Mexico to handle something like this, to establish it was a sexual assault, would take 2 witnesses, some things where does that fit in to, it's one thing, again, if it's a Mexican citizen trying to, nothing against somebody from out of the country, but I think that's where a lot of the United States cases came from. Somebody, again, the Scottish one was the big one where there was a plane crash in Scotland and then they want to sue here. But do you see that any cases within the United States have really talked about that issue, that it's one thing if you're going to transfer it to California or someplace, but to have a Mexican court evaluate even whether there's a cause of action for the negligent packaging of the vacation package in Florida seems strange to me.
Ms. Robbie's expert spoke directly to that issue, and Ms. Robbie's expert, and really her declaration goes to the issue of the adequacy of the forum. We could potentially concede that Mexico is available to the extent that the defendants are willing to submit to the jurisdiction of the court, although that is also an issue that our expert suggested would not necessarily be the case. But with respect to the the adequacy of the forum, yes, there are significant problems that someone like Ms. Robbie, the victim of a sexual assault, as opposed to someone who is simply suing on a commercial or an otherwise non-tort civil matter, would face. She would face the possibility of not being able to retain counsel. She would face the possibility of receiving nominal damages, anywhere from $5,000 to $15,000. She would face the possibility of reduced access to evidence because, in fact, it is unclear, based on our expert's testimony, that she would even be able to sustain any type of a claim in Quintana Roo, in Cancun, in Mexico, primarily because these types of cases are typically not litigated. In fact, our expert testified that in absolute terms, she could not think of a single case, and she is an active litigator in the state of Quintana Roo in Mexico, where the defendants seek to transfer this case. She could not think of a single case of this nature that had been raised. So the question of whether or not the state of Mexico or Quintana Roo is even an available forum for this case is very much in dispute, and it was never directly rebutted.
Well, we don't really know such a cause of action exists in the state of Florida, because I've a negligent packaging case, correct?
Certainly. That's not an issue that has been litigated. It is not a substantive issue that was litigated in this case. That's absolutely correct, Justice Perianti. Absolutely correct. But with respect to that secondary issue, yes, the unrebutted testimony from our expert is that Ms. Robbie would not be able to sustain a claim in Mexico, and even if she could sustain a claim, the remedy would not necessarily be a significant or sufficient remedy.
Now, well, it makes, again, if your claim really, again, we have to assume a cause of action for this purposes of this discussion, it doesn't even make sense that Mexico would have a particular interest in how a business doing business in Florida would market its vacation to citizens of the United States.
And if they do have an interest, it's a minimal interest at best.
Well, their interest might be that they want that to occur because it's a resort that they want Americans to come to.
Absolutely. And Palace's resort, or Palace's business, is based upon that. They run the timeshare operation out of Florida as opposed to Mexico because the individuals that they are courting for these timeshare sales are United States citizens out of Florida. Palace Resorts runs 70% of its U.S. business. And so the interest of this state in ensuring that Palace Resorts provides a non-negligent vacation package, assuming that ultimately is established at a motion to dismiss on the question of a claim, whether we pled a claim, is significant with respect to our question here today, the contacts, and whether or not this case, this forum, the public interests, militate in favor of keeping this case in the state of Florida. I see that I'm into my rebuttal time. I would like to reserve the remaining time. Thank you.
Thank you.
Good morning, Your Honor. Good morning, Chief Justice Polston and Honorable Justice of this Court. My name is Ricardo Cata, and this is my colleague, Ronnie Guillen, and we represent the respondents in this case. If I may, I would like to go back to your question for a moment. I don't think there is any conflict shown, direct conflict shown. In fact, the cases that we cited from the 3rd District, which were in place after Kenny and before this decision, Hilton International versus Carrillo. You have a citizen of the United States who there was a terrorist attack in Egypt, and there was Hilton International had a big operation in Miami at that time, and the court, after examining all of the factors, weighted all of the factors, sent the case back to Egypt. The same thing with Kearson International versus Resorts versus Reigns.
Well, would you give us the facts in Kenny? Where was the plaintiff from?
In Kenny, Kesna maintained a marketing office in Florida. Mm-hmm. The office activities had nothing that was a finding to do with the accident in the Bahamas. I believe it was a boating accident, if I remember correctly, in the Bahamas. Plaintiffs were residents of Illinois. The accident occurred in the Bahamas, and the trial court dismissed on foreign nonconvenience under Kenny, and the 3rd District Court.
Well, maybe I'm talking about Kenny, which is the...
Oh, Kenny.
Yeah, the conflict case. I thought that's what we were here on, is that Kenny was involved. It's a dispute about workers' compensation insurance premiums.
Right.
And where was the plaintiff from?
I believe, Your Honor, if I remember correctly, the plaintiff was from, I want to say New York or Northeast.
Yeah, and didn't we hold in that case, and we adopted a rule that said that the plaintiff's choice of forum should be entitled to, let's just make sure, it's that finds weighing in a balance a strong presumption against disturbing the plaintiff's initial forum choice. So unless the case and the rule were all dicta, it couldn't be dicta because the plaintiff was not from Florida.
That's correct.
It was from this country, and they said that plaintiff's initial choice of forum is entitled to great deference. They didn't say it was less deference because they're from New York.
Well, that's what the cases since then have held.
Not from this court.
Your Honor, but the Kenny decision said that presumption can be overruled and could be defeated.
If it's from if the private factors and those other things. But I thought what the 3rd District said is that the strong presumption is not as strong if it's an out-of-state plaintiff, and that's just contradictory to the facts of Kenny.
I don't think so, Your Honor, with all due respect, because Kenny said that the boundaries of the Florida courts, the jurisdictional boundaries of the Florida courts are at the boundaries of the state, and there's very good reason for that. The federal courts can transfer cases anywhere in the United States. The Florida courts cannot do that. They will have to dismiss if this is not an adequate forum. The other thing that the decision in Kenny put out, which is still the case today, and that was raised by the amicus brief on behalf of respondents, is that the Florida courts were becoming the courts room for not only all of the United States, but for the world and any action.
I think that Kenny is good policy. I'm not arguing. I thought you were really addressing whether there was conflict, and it seems to me that we'd have to recede. If we agree with the 3rd District, we would, in my view, the reason there's conflict is we would have to recede from Kenny. And I understand there are cases from other appellate courts after that. But could you, assuming we get through the conflict issue, do you agree that the defendants now, there are 3 defendants left, that they are all primarily based in Florida?
They have their primary base in Florida, and if I may address the other points you raised before, the facts as found by the trial court and the 3rd District decision, the majority decision, are very clear, and there was also a significant record in front of the courts. It wasn't just 2 affidavits, Your Honor. There were 11 depositions, there were interrogatory answers, there were a significant amount of discovery documentation, and there were also the affidavit of the parties and the expert. The fact is that Traco Inc. had nothing to do with this case. That was found very clearly by the trial court and the 3rd District Court of Appeal. Traco Inc. is a travel agency. It had nothing to do with this case whatsoever.
Well, it wouldn't have, if it doesn't have anything to do with the case, it won't have anything to do with the case in Mexico either, will it?
That's correct, but I'm just saying what it was found. So they should be dismissed.
In other words, I guess my problem about it is that if there's no cause of action, and I'm skeptical about it, seems to me against Florida corporations that are primarily doing business in Florida, seems to me the Florida courts are in the best position to determine that. So if your clients really had nothing to do even with the packaging of this vacation, that's then either summary judgment or a motion to dismiss for failure to state a cause of action. It's not a reason, because that's preliminary, to transfer it to Mexico, for Mexico to decide whether Florida would recognize a cause of action for negligent packaging against Florida corporations primarily doing business in Florida. See, that's where I think that we may be crossing.
I was going to get to that. Okay, because what I was trying to point out is that really the one respondent that is involved directly with vacationing, marketing promotions in the United States is Palace Resorts, Inc. And that's the point I was going to make. Palace Resorts, Inc. had nothing to do, had no contact whatsoever with the petitioner, and that's on the record before they were enacted.
But isn't that a basis to either a judgment on the pleadings? Okay, I'm sorry. I'm just not seeing how that has anything to do with the forum.
If you look at their amended complaint, which is the pleading from the trial court and from the 3rd District, I'm in front of you here, what they're alleging on count 6 of their amended complaint, their only account against our clients, which also included the Mexican defendants, is that they were negligent for not inspecting the spa in Mexico. They were negligent for not investigating the masseuse in Mexico, for retaining the masseuse in Mexico. Everything that they allege against my clients in Florida has nothing to do with Florida, has nothing to do with what they did in Florida. It doesn't even really have to do with anything with vacation packaging, whatever that is. I never heard of that before. It really has to do with what allegedly they didn't do in Mexico. And that's why the trial court found that in order to litigate this, we have to be in Mexico, because all of the records of the masseuse, the hiring, the training, the retention, all of the investigation by the police, all of the investigation by the crime section, there was a significant amount of interest, contrary to what was said before.
But are those really the kinds of things that you need to demonstrate in order to show, assuming there's a negligent packaging of vacation things, isn't it more important as to what they did putting the package together as opposed to what happened after she got to Mexico?
No, Your Honor, with all due respect, I don't think so, because this is a vicarious liability claim. No matter what they call it, and the 3rd District put a finger on it, it's a vicarious liability claim in tort against my clients for what happened in Mexico.
But if you have no control, if your defendants have deposition testimony, and it is uncontroverted that they had no control over who was hired, then that is again, I don't want to, whether it's judgment on the pleadings, motion for summary judgment here. We are able to evaluate that when somebody says, well, you should have not hired that masseuse. That's not, you don't need to go to Mexico to do that. Aren't the records about what you did at least according to Judge Rothenberg's dissent, here in Florida?
Judge, you cannot try a negligent vacation package and a vicarious liability claim in a vacuum. You have to try it in contrast with what happened.
Well, you
in
want
Mexico.
it to be tried. I'm sort of giving you the out that I think you could get it either a summary judgment or judgment on the pleadings, because I don't see where where the lawsuit is that needs to be tried in Mexico.
They want to try it, Your Honor, and we're always saying, and the trial judge agreed with that, and so the majority in the third district, if you want to try a vicarious liability tort claim against a Florida client for what you are alleging happened only in Mexico, there's no allegation of anything happening in Florida, then you need to try that case in Mexico. That's where all the facts are. That's where all the witnesses are. That's where all the documents are. You're talking about retention. You're talking about screening of the masseuse, hiring the masseuse, supervising the masseuse, because that's what they're alleging, that we negligent, didn't inspect, didn't warn. There's no indication that she even talked to us. In fact, it was Costco Travel, not Palace Resorts Inc. or any of the respondents who suggested to the petitioner that she goes to the Moon Palace. It wasn't our clients, and whoever accosted her in Mexico, as she alleges in the count, was not us. She's saying it's people from Palace Premier, which is a Mexican entity. Everything that she's alleging in order to allege the vacation packaging against our clients, it's based in Mexico. Every fact, every record, everything is based in Mexico. That's what the trial court found. That's what the majority of the third
finding, as I understand, there was no evidentiary hearing.
Well,
I mean,
there
in
was
other
not
words,
an evidentiary hearing, and none is required, but there was a significant record developing in front of the judge.
Can't we look at that record and look at what Judge Rothenberg said, which has now been established? The plaintiff is that Miami is the operational, managerial, and marketing center for the entire Palace Resorts Group, and that the Florida defendants control marketing, sales to individuals, groups and travel agents, timeshare, customer service, press relations, and finance for the entire Palace Resorts Group. They manage the entire U.S. market, which represents 70% of the business, and the president lives and works in Miami. The Florida defendants employ nearly 100 employees in Miami, and further states that the Florida defendants and Ms. Rodriguez now admit that the allegations that were previously made about whether any money was made off of this, they admit are false. Now, that's some pretty serious stuff from this, the record in this case.
Okay, that's what Judge Rothenberg found. That's not what the trial court found. That's not what the majority of the third district found. In fact, the majority of the third district, a couple of times, at least once, but maybe a couple of times, said that the respondents have no ownership, managerial or operational control of the entities in Mexico. There are less than 100 employees here. There are a dozen hotels in Cancun, thousands of employees in Cancun. They found clearly that they do not control, they do not manage, they do not own. As to Ms. Rodriguez's statement, and in fact she was there at the hearing with me because she insisted to be there, she made some factual errors in her affidavit, and she corrected them 3 months before her deposition, and she explained why she processed that way. In fact, it was alluded to during the argument by counsel that they don't receive money, Palace Inc. They don't receive money directly, in this case or the other cases, from the tourists, Miss Robbie Cortez, or from Costco Travel. They receive it indirectly through a annual budget that they get from the Mexican entity. And she explained that, and she had corrected that 3 months before. So yes, there are serious allegations, and she took it very seriously, Your Honor, and she insisted to be there with me. And in fact, I offer to Judge Hubbard that he would hear her, and he declined, and he had the entire record in front of him at that time. But going back to the issue of the control, that was clearly found not to be the case by the trial court and by the majority of the Third District Court of Appeal. Now, Judge Rosenberg differed with that, but that's the definition of whether or not there is an abuse of discretion, whether reasonable persons can differ. The trial court found that all of the key factors have been considered and weighed in favor of dismissal.
I don't understand. If you don't control or manage or have anything to do with Palace, and the record reflects that, wouldn't the alternative have been move for a judgment on the pleadings in favor of your clients based on the undisputed evidence that they had nothing to do with this sexual assault, they had nothing to do with hiring this masseuse, they had nothing to do with the management down in Mexico, and it's the end of the case, but it's ended in Florida.
No, Your Honor, I think that the way they're suing us for something that happened in Mexico, by their own pleading, everything that they're alleging against us happened in Mexico. The hiring and so forth happened in Mexico. We're saying if you want to sue us for that, we have no control over that, but if you want to sue us for that, in order for us to prove that we were not negligent, you need to try that in Mexico. And going back to your previous question, Your Honor, about the cause of action, if I may, this is not a criminal prosecution that will take place in Mexico. This is not a prosecution by an action that would require to prove whether a sexual assault happened or not. In fact, their own expert, Ms. Avaya, said that she can prove that by her own testimony and by the testimony of third parties. Our expert, Mr. Garcia Pimentel, said the same thing. In fact, in his response to Ms. Avaya, which we filed on October 2nd of 2009, he specifically said she could prove that through her own testimony because it's a vicarious liability action and the testimony of the police and other witnesses. And the police has expended a lot of time investigating this, and there's a lot of evidence on the record that well, I don't know about the record, but there's a lot of indication that the Quintana Roo police and prosecutors were very interested in this case, Your Honor. Now, the other thing that you raised before, Your Honor, if I may, the contingency fee. Both experts said that she can get a retainer lawyer and contingency fee in Quintana Roo, so it's an adequate forum. Ms. Pimentel, in his response, said it happens all the time. She was kind of all over the place, Ms. Ovalle. She said, well, they're rare, I never seen it, but at the same time she says, well, but if you bring them, it would be a minimal recovery. I don't know where she came up with that. Mr. Pimentel, in his response, said there was a medical malpractice action in 2009 where there was a recovery in Mexico for $4.5 million. If you look at Ms. Ovalle's CV, a lot of her papers that she has written is on product liability. So obviously, she said that civil liability litigation is not developed in Mexico. Well, she herself has been doing a lot of that by her own admission. They can take evidence, they can compel witnesses. We will not be able to do that here in Florida. All of the things are important. Judge Hubbard found that all of those private interests weigh heavily in favor of the respondents. And enter the order, and also that we have preserved the ability for her to reinstate her lawsuit in Mexico if she chose to do so. The other things that were raised, Your Honor, were whether or not there will be an evidentiary hearing, and we stated in a brief that first of all, no evidentiary hearing was requested by a petitioner, and there's no case law that decided that an evidentiary hearing will be required on a foreign nonconvenience hearing. The hearing was 1 hour and 20 minutes long, extensive briefing, extensive record. The other thing they said is that there should have been a de novo abuse of discretion, de novo review. That's a very narrow exception of the Third District Court of Appeal, and the majority of the decision itself found that in this case, because the trial judge had considered all of the key factors, no abuse of discretion and de novo review was required. And the other thing they say is that a lot of the things they raised for the first time on the petition for a hearing on the third DCA, not in the initial brief, is that the trial judge violated the Privileges and Immunities Clause of the U.S. Constitution. We cited cases, I believe it was Douglas and Mayfield from the U.S. Supreme Court and from about a dozen states, including California, where a lesser deference is given to a plaintiff, an out-of-state plaintiff, a U.S. citizen, out-of-state plaintiff. A lesser deference is given by the forum state chosen by the plaintiff if he or she is not a resident of that state. And there's nothing unconstitutional in the context of a foreign nonconvenient dismissal in that scenario. We also approved the public interest factors weighed heavily in favor of dismissal, and that was found by the trial court and also by the majority in the Third District Court of Appeal. So I think that we carry our burden. It was found to be the case by the trial judge and by the majority of the Third District Court of Appeal, and I think that deserves significant consideration. And again, going back to the abuse of discretion standard, which is what we have here, different persons can differ. That's the very definition of whether or not there is abuse of discretion. We believe that there was none, and we believe that the only way that we could defend this cause of action that they have alleged against our client solely in Mexico, nothing here in Florida, it would require for us to be able to defend it in Mexico, not here. Otherwise, we'll be litigating the case in Mexico and bringing the evidence to Florida.
But the allegations really are related to acts that occur in Florida, correct?
Well, but no. Excuse me, Your Honor. The allegations are that we failed to inspect the spa, that we failed to warn the plaintiff about the masseuse, the vendor, and the spa. Those allegations in the amended complaint, count 6 of the amended complaint, speak only about Mexico. And in fact, they incorporate all of the other factual allegations in that in the opening line of that count 6, and all of the factual allegations that they set forth clearly and only talk about Mexico. Everything related to Mexico.
It seems like those would be business actions taken, though, by your client in Florida. And to that extent, it would go to the public interest of Florida to make sure that there are not tortious acts occurring within the state.
Your Honor, there's nothing showing that any of the actions that they're alleging in the count 6 were taken in Florida. Everything that they allege in count 6 of their amended complaint, they allege happened in Mexico. And that's the beginning of the analysis for the private interest, is the pleading of the plaintiff. What are they saying, and where are they alleging that things took place?
Is that a question of fact that's missing in the case?
I don't think so, because they allege that. That's what they have alleged. They have alleged that we did all these things in Mexico. So we have to, the private interest factor has to be, if they're alleging that we did the things in Mexico, then that's where the matter should be tried. Thank you, Your Honor.
With respect to the conflict issue, in its majority opinion, the Third District Court of Appeal wrote, quote, the proceeding against the appellant, a California resident, chose to file suit in Florida, a forum that is not her residence. Thus, she is not entitled to a strong presumption in favor of Florida as her initial forum choice. That is not the law. It is not the law as articulated by this court in Kinney. It is not the law as articulated by federal precedent.
But Kinney wasn't addressing that kind of factual circumstance, because in Kinney, there were two corporations that actually had activities going on in Florida. Both the plaintiff and defendant had offices and operations in Florida. Isn't that the facts that they were addressing there?
Well, actually, Your Honor, I would disagree to the extent that Kinney and Robbie are entirely distinguishable, because both defendants in Kinney and defendants in Robbie do have significant operations in Florida. Actually, the defendants in Robbie, as alleged, have more significant operations in the state of Florida.
Well, the point was that the plaintiff also had connections with Florida and had an office in Florida and operations in Florida. And that's very different from the plaintiff in this situation, who, so far as we know, has no connection at all with Florida.
But Kinney did not limit its holding with respect to the plaintiff's choice of forum to those specific facts. In fact, it expanded it by incorporating federal precedent to the extent that it harmonized with the principles in Kinney. The problem, and I would agree with Justice Pariente, that Kinney works. But what's happening in the state of Florida right now in the lower courts is that Kinney is not being applied as conceived by this court. What we have is nothing more than a balancing of accounts. Courts are looking at two sides of a single piece of paper. How many witnesses here? How many witnesses there? How many documents in the foreign jurisdiction? How many documents in the local jurisdiction? That's not how Kinney was conceived. It is not how you balance, for example, the private interest factors. In fact, what many of the federal courts speak to, and Judge Moreno has spoken to this issue in the Southern District of Florida, is with technology, for example, the question of where the documents are becomes a non-issue. The question of what language the documents are becomes a non-issue. Witnesses become a non-issue because you can use technology to obtain their testimony and show it to a jury. But that's not Kinney. And
let's assume that you're correct on your analysis of Kinney, and let's assume that there is jurisdiction. But your opposition makes, very clearly the point, and I don't know how it could be contested, is that the underlying facts of what happened to the plaintiff occurred in Mexico. You cannot try this case in a vacuum. And that seems to be what they're saying, is that you may have made some bad decisions, but that can't be considered in a vacuum. It has to be considered in connection with what's on the ground in Mexico, and therefore we have joint, there are things that went wrong in two places. And so I think your opposition is arguing is that, the real gravamen of what happened here is what happened to the lady in Mexico. How does one balance? Even if we agree that Kenny says that they should have some deference because they selected Florida and it's a Florida defendant. This is not a long-arm jurisdiction type analysis. This is not one of those foreign corporations, are they doing business? That's not what this is. So how does that analysis take place here? Because it's inescapable what they say is that the underlying harm, the bad acts, at least half of them, and the direct acts on the plaintiff occurred in Mexico. Help with that analysis. How do we walk through that?
Justice Lewis, I have two responses to that question. The first is, it is conceded that Ms. Robbie was assaulted in Mexico.
Well, I don't know. For the purpose of this litigation?
Well, I concede that this action took place in Mexico.
Well, maybe it didn't happen at all. They may say this didn't happen. So you're going to have to prove that something happened to her in Mexico.
Absolutely.
Okay.
Absolutely.
All right. Let's start with that premise.
The first response is, it is correct that there are difficulties facing both sides. But in balancing the challenges that both plaintiff and defendant face in this international dispute, Ms. Robbie's choice of forum still tips us over the edge and takes us to Florida if the private interests, if we can say that the private interests are in equipoise, if both sides are going to face challenges, and they are, conceivably, although I would suggest to the court that the way that my colleague Mr. Cotta paints the picture is not so grave with respect to defending this lawsuit. Here's an excellent example of why this case belongs in Florida. When Ms. Robbie reported her assault and she contacted Costco, who was originally a defendant in this case and who sold her that package, who did they contact?
I understand your argument. They came to Florida. Yeah.
They contacted the Florida defendants. The Florida defendants managed that investigation. The Florida defendants received significant amount of discovery with respect to that complaint.
But that's all after the fact. The point being is that they're arguing is that if they did something wrong, it happened before this lady went to Mexico.
Yes.
All right? And so then she's allegedly attacked in Mexico. And the facts of the harm, the devastation on this young woman are occurring in Mexico. The fact that it's reported later to Florida, is that entitled to a heavier balancing when it comes down to the public interest as to how this should be?
Justice Lewis,
how should be handled?
Justice Lewis, as you said before, first, it's their pre-act conduct that I think is relevant and creates a tie to this jurisdiction. Second, it's their post-act conduct that creates a tie to this jurisdiction, both how they packaged this vacation and then what they did after they were alerted to the fact that this particular package had resulted in Ms. Robbie's injuries. I see that my time has elapsed. I thank the court very much. Thank you.
Thank you for your arguments. The court is adjourned till tomorrow.
All rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.